Welcome to EPG Pathshala. This is Professor Arvind Tiwari, Professor of Criminology, School of Law, Rights and Constitutional Governance at Tata Institute of Social Sciences, Mumbai. I will discuss on the module entitled Victims of Terrorism in India. The structure of the module would be like this: introduction, then elements of a comprehensive definition of terrorism, then evolution of terrorism, international response, normative framework under which various laws like Unlawful Activities Act, National Investigating Agency Act, the National Security Act, Prevention of Money Laundering Act, Armed Forces Special Power Act, etc. would be discussed. Terrorism in India, the contemporary scenario, then the victims of terrorism and their rights in the Indian criminal justice system will be dealt, societal response for victims of terrorism, and finally the summary of the module would be discussed. Now, to begin with, the introduction section would deal as the terrorism as a phenomena as old as Roman Empire, and it existed in some or other form since the many centuries, particularly from 11th to 13th century, with religion being a strong motivating factor behind terrorist activities until the French Revolution. In fact, the term terrorism originated from region of terror of 1793-94. In India, such activities have happened in 1970s in Assam and certain northeastern states, and in the next decade in Punjab. Thus, terrorism is not a new phenomena, and yet it has become fundamentally different from anything that was known before the destruction of Twin Towers of the World Trade Center in New York. The attacks in the USA on 11 September 2001 capitulated terrorism into the international eye by their visibility, sovereignty, and symbolism. The impact of this event was not just on public perceptions on terrorism, it also galvanized a powerful actor to drive the global community in the new direction in responding to terrorism. A new response emphasized the major legal elements like control of financing of the terrorism through tighter international monetary mechanisms and security by force using police and military as the means to achieve this. Now, we will discuss the definition of terrorism. What is terrorism? The terrorism may be defined as an act of organized violence to create chaos and disorder for achieving the goals which in normal course cannot be realized within the framework of legal and constitutional institutions. It is an act of intimidation seeking to subjugate the people and the governments into acceptance of their points of views and also the methodology to propagate it. Terrorism can be defined as an unlimited use of violence against a target by a set of people in order to get undue publicity to their ideologies with a view to bring the government to the negotiation table. The target can be people waiting in the platform of a station or symbolic like places of worship, government buildings or in officials. The terrorists are always in search of soft targets so as to attract world attention and make their presence felt, whether the motivation is economical, political or ideological. The rapid spread of violence seems to be eating the vitals of an organized social order. The innocent citizens who may be remotely connected with terrorism or terrorist cause become the major victim of terrorist violence. The increase in terrorist violence and incidents of terrorist activities has usually been a cause of panic, giving rise to fear psychosis among the people. Now, I will discuss about the elements of a comprehensive definition. From a human rights perspective, support is most likely to coalesce around a definition that focuses on indiscriminating or targeted violence against the civilian which aims to spread terror. The definition formulated by the high-level panel of threats, challenges and changes provide a starting point, although no consensus among human rights organizations had yet emerged to support it. In its 2000 report, A More Secure World, the high-level panel described terrorism as any action that is intended to cause death or serious bodily harm to civilian or non-combatants when the purpose of such act by its nature or context is to intimidate a population or to compel the government or any international organization to abstain from doing any act. In India, the first special law which attempts to define terrorism was the Terrorist and Disruptive Activities Prevention Act, which is known as TADA in 1987, which was followed by the Prevention of Terrorism Act 2002, known as POTA. However, these laws were repealed in 2004. Then the Unlawful Activities Prevention Act 1967 was amended in 2004 to include the definition of terrorist act. Section 15 states, whosoever with intent to threaten unity, integrity, security or sovereignty of India or to strike terror in the people or any section of people in India or in any foreign country does any act by using bombs, dynamite or other explosive substances or inflammable substances or firearms or other lethal weapons or poisons or noxious gases or other chemical or any other substances, whether biological or otherwise, of a hazardous nature in such a manner as to cause or likely to cause death or injuries to any person or persons or loss of or damage to or destruction of property or destruction of any supplies or services essential to life or the community in India or in any foreign country or causes damages or destruction of any property or equipment used for the defense of India or in connection with any other purposes to the government of India, any state government or any of their agencies, or detains any person threatened to kill or injure such person in order to compel the government of India or in the government of a foreign country or any person to do so or abstain from doing any act commits a terrorist act. So, this is the broad definition. Now, I will discuss about the evolution of terrorism and its international response. Anti-terrorism measures have a long and varied history. Nationally, most countries including India have some measures to deal with terrorism, and internationally UN counter-terrorism conventions date from 1960s. As terrorism globally shifts and evolves, bilateral, cross-borders and regional instruments increasingly complement the framework of conventions established by the United Nations. The late 1980s saw activities emerge at a different UN level. In the Commission on Human Rights, government led by Colombia and Peru started pushing for a resolution on the threat to human rights posed by the activities of armed opposition groups. In 1990, the Commission adopted a resolution entitled Consequences of Acts of Violence committed by armed groups that spread terror among the population and by drug traffickers on the enjoyment of human rights. Between 1995 and 2004, a different type of resolution on human rights and terrorism was passed each year. The subcommission for its part, appointed a special rapporteur to conduct a study on human rights and terrorism that was finalized in 2004. It is noteworthy to mention that whereas human rights advocates have striven to demarcate clearly in their advocacy and report the line between violations of human rights committed by states and human rights abuses committed by non-state actors such as legal necessities have not been observed by other important human rights actors. It is important to mention that member states adopted the United Nations Global Counter-Terrorism Strategy on 8 September 2006. The plan of action include the following 4 measures. Now, measures to address the conditions to the spread of terrorism, including but not limited to prolonged unresolved conflicts, dehumanizations of victims of terrorists in all its form and manifestations, lack of rule of law and violations of human rights, ethnic, national and religious discrimination, political exclusion, socio-economic marginalization and lack of good governance. Measure to prevent and combat terrorism, in particular by denying terrorists access to means to carry out their attacks to their targets and to the desired impact of their attacks. Measures to build states' capacity to prevent and combat terrorism and to strengthen the role of United Nations systems in this regard. Measures to ensure respect for human rights for all and the rule of law as the fundamental basis for the fight against terrorism, reaffirming that the promotion and protection of human rights for all and the rule of law is essential to all components of the strategy, recognizing that effective counter-terrorism measures and the protection of human rights are not conflicting goals, but complementary and mutually reinforcing, and stressing the need to promote and protect the rights of victims of terrorism. Yet, despite 13 international counter-terrorism conventions and an attempt made by UN in Security Council define the term in 2004, the international community failed to agree on a legal definition of terrorism. Now, I will discuss about the normative framework. In keeping with the requirement of dealing with the menace of terrorism, India has put in place a comprehensive legal infrastructure. There are several pieces of legislation, of which some of them are listed below. 1. The Unlawful Activities Prevention Act 1967. This was amended in 2004 and 2008. Next is the National Investigating Agency Act 2008. Next, the Code of Criminal Procedure 1973, amended in the CRPC. The Prevention of Money Laundering Act 2002. Next is the Armed Forces Special Power Act 1967, the National Security Act 1980, the Arms Act 1959, the Explosive Act 1884, the Explosive Substance Act 1908, the Indian Penal Code 1860, the Anti-Hijacking Act 1982, the Unlawful Activities Prevention Act 1967. The Indian Parliament initiated this act in 1967 to make powers available to the law enforcement agencies for dealing with unlawful activities directed against the integrity and sovereignty of India. It provides for effective prevention of certain unlawful activities of individuals and associations, including terrorist organizations. It extends to the whole of India. This law, enacted to provide for more effective prevention of certain unlawful activities of individuals and associations and for more matters connected with it. It empowered appropriate authorities to declare any association as unlawful. It is carrying out unlawful activities. This law was comprehensively amended by the Unlawful Activities Prevention Amendment Act in 2004 to deal with terrorist activities like POTA. It defines a terrorist act and also defines a terrorist organization as an organization listed in the schedule or an organization operating under the same name as an organization so listed. It further provides a mechanism for forfeiture of the proceeds of terrorists apart from providing stringent punishments for terrorism related offences. In the wake of the mayhem unleashed in Mumbai on November 26 to 28, 2008 by a group of 10 Pakistani terrorists, which left 173 dead and 288 persons injured besides substantial damage of property, the National Investigating Agency was launched on January 1, 2009. A day earlier, December 31, 2008, the President of India had given assent to the National Investigating Agency Act 2008 and the Unlawful Activities Prevention Amendment Act 2008. Under the Unlawful Activities Prevention Act 1967, after its amendment in 2008, an accused can be detained without trial for 180 days. The NIA will have all the powers invested in it by the NIA Act 2008 and the procedure and punishment prescribed in the Unlawful Activities Act as amended in 2008 should be able to assist the center and state government to control terrorist activities in India and prevent a replication of the Mumbai attack. National Investigating Agency, the Indian response. Immediately after an attack of terrorism in Mumbai, the government of India responded by creating a highly specialized force to deal with terrorism in any part of India called the National Investigating Agencies, in short NIA. The NIA Act prescribed the whole procedure. Later on, the National Security Act 1980 also deals with the definition pertaining to the terrorism. This provides the power to the central government and state government to make order to detain certain persons, including foreigners, whose action may be prejudicial to the defense of India, security of India, prejudicial to the maintenance of public order and maintenance of supplies and services essential to the community. Another law is Prevention of Money Laundering Act 2002. Section 2 of this law says, whosoever directly or indirectly attempts to indulge or knowingly assist or unknowingly is a party or is actually involved in any process or activity connected with the proceeds of crime and projecting it as untainted property shall be guilty of the offence of money laundering. Another law, Armed Forces Special Power Act 1967, section 3 also describes that the whole or any part of the country or state can be declared as a disturbed area by the central government or any governor of the state. Enter the search without warrant any premises suspected to be used by any illegal purposes as defined under the Act. Under this Act, arrested person to be handed over to the officer in charge of the nearest police station with the least possible delay. Further, the above provisions confer sweeping powers on the members of armed forces, and since they are likely to be misused, the Supreme Court of India has issued 11 commandments regulating the exercise of powers under this Act. Now, I will discuss about the terrorism in India. What is the contemporary scenario? India has been among the major victims of terrorism mostly cross-border and state-sponsored terrorism for, for around 2 decades. According to an estimate, India lost over 53,000 lives to terrorism over the last decade. In comparison, it lost 8,024 lives in all its wars since independence, including Kargil. In other words, terror attacks in India have blown the country much more than conventional war. More recently, in 2016, India ranked third among the world's most terrorist affected countries. Now I will talk briefly about the victims of terrorism. Human rights advocates and organizations generally face the criticism that they fail to give adequate attention to victims' rights. This criticism takes two forms. One is a demand that human rights organizations should advocate more actively for victims' compensation. On this matter, human rights organizations would normally agree that government should compensate victims of attack and provide restitution where this is possible. They also have a responsibility to arrest and prosecute individuals responsible for such attacks. At issue, therefore, is whether they give enough attention to this question. A second more radical critique is that human rights organizations are partial in their advocacy. It is argued that they focus disproportionately on the rights of detainees and fail to highlight equally the right of ordinary people to security, their right to life, to freedom of movement, and to freedom from fear, which are no less fundamental to the notion of civil liberty than the rights of detainees. The true victims of terrorism are society itself. Terrorism not only subverts the political and social climate, but also threatens the economic stability of the country, undermines democracy, and even deprives ordinary citizens of their fundamental rights, including their right to life. A spate of bomb blasts in prosperous metros has a spark of security management and terror insurance cover as the new board room buzzword. A recent survey carried out by the Mahindra Special Service Groups showed that a majority of corporate, 97%, viewed security as an area of increasing priority in the future. It is estimated that a medium-sized corporation spends about 7 crore annually on engaging the services of private security industry that is valued about 10,000 crores. The fear of terror attacks in industry and various religious institutions across Mumbai is constantly increasing. Consequently, these establishments pay an annual premium of 65 crores for cover against terrorism. The corresponding figure for Maharashtra is approximately 250 crores. So, with this discussion, it is evident from the above that terrorism terrorism is impacting the larger society indirectly as price of commodities do increase due to security and terror related expenditure incurred by the companies. Another dimension of terrorism is that the criminal justice agencies, police, prosecution, judiciary and prisons are giving much attention to the terror related matters, and access to justice for poor and socially excluded people is becoming bad to worst. Now briefly we will discuss about the rights of victims in Indian criminal justice system. Victims of crime are important players in criminal justice administration, both as complainant or informant, as witness for police, prosecution. Despite the system being heavily dependent on the victims, criminal justice has been concerned with the offenders, and his interest is almost subordinating or disregarding interest of victims. However, a common understanding regarding the necessity of promoting the protection and support of victims of crime developed. This development, which mainly took place in the Western countries after the 1960s, can be divided into three stages. First, the first stage was the establishment of a system of monetary support for the victims, particularly in 1960s. The second stage was the strengthening the immediate and direct support for the victims, 1970s. After the second stage, there was a realization that the victim in the criminal justice processes had very few rights, and the actual process sometimes victimized them a second time, and this led to the third stage. The third stage has brought about the enactment of a statute for the improvement of legal status of the victim and the establishment of rights of victims. Particularly, this started from 1980s. The adoption by the General Assembly of the United Nations at its 96th plenary on November 29, 1985 of the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, hereafter UN Declaration, constituted an important recognition of the need to set norms and minimum standards in international law for the rights of victims of crime. The UN Declaration recognized four major components of the rights of victims of crime. 1. Access to justice and fair treatment. 2. Restitution. 3. Compensation. And 4. Assistance and rehabilitation. While all the above rights enshrined in the UN Declaration on the Basic Principles of Justice for Victims of Crime and Abuse of Power are applicable to the kinds of victims of crime, there is a special need to distinguish the victims of terrorist violence to alleviate their sufferings in view of increasing phenomena of urban terrorism and its impact on terrorism on the victim and their families, criminal justice system and the larger society. In India, there is no comprehensive legislation for compensation to the victims of terrorism. However, the Government of India, Ministry of Home Affairs has notified a scheme entitled Assistance to Victims of Terrorist and Communal Violence, which is being implemented with effect from April 1, 2008. The scheme provides financial assistance to the family members in the event of death or permanent incapacitation of the victim in terrorist violence. The assistance would be given over and above ex gratia or any other relief from the state government or its agencies. An analysis of this scheme shows that the scheme is mainly based on welfare approach and not on rights-based perspective. The victim does not have any right to get compensation. However, the financial assistance would depend on recommendations made by the bureaucrats, police officials and the doctors. Further, this does not include any component for other support systems such as counseling, assessment of loss, damage and property, financial expenses and other out-of-pocket expenses by victims and their families, and also medical expenses incurred in the private hospitals. The procedure to get the financial support is very cumbersome and time consuming. The whole process gives lot of discretionary powers to the bureaucrats, and therefore this will result in delay in disbursement of the compensation to the victims. The element of corruption may also not be ruled out while awarding the compensation for the victims. Now, briefly I will discuss about the role of civil society in the victims of terrorism scenario. In response to recent terror attacks in metropolitan cities like Ahmedabad, Surat, Bangalore, Hyderabad, Mumbai, etc., the civil society organizations and concerned citizens have severely condemned and also shown solidarity with the victims and their families. In Mumbai, demonstrations were organized against the political leadership for their failure to provide safety and security to the citizens. In fact, these attacks have provided ground for the coming together of the poor and the vulnerable with the more affluent to demand greater state responsibility and accountability. Besides demonstrations and condemnation of the political establishment, the civil society organizations have also raised money in partnership with corporate sector and concerned citizens, which was provided to the victims and their families to meet medical expenses and social rehabilitation. Besides civil society organizations, media, both print and electronic, has also taken up vigorously devastating effects on terrorism, suffering of victims and their families, and also community support to the victims of terror attacks. This acted as a pressure put on the government to implement police and legal reform. Now, I would summarize the module. There is justifiable criticism that the present criminal justice system is totally centered around the accused, ignoring the victims for whom the system perpetually existed and is supposedly operating. The UN has also acknowledged this indifference to the victims of terrorism and called upon member states to amend their laws and procedures, giving special rights to victims to participate in criminal justice proceedings and to claim compensation and other support irrespective of the outcome of the case. The Committee on Criminal Justice Reform, which is known as Malimat Committee, recommended empowering of the victims of serious offences with the right to impede themselves as a party, right to be represented by counsel, right to produce independent evidence and cross-examination witnesses with the permission of the court, right to be heard in the manner of bail, right to continue with the case of prosecution, short withdrawal, and the right to advance argument and to prefer an appeal against an adverse order. There is also a need for victim protection schemes in certain situations. The state should ensure rehabilitation of helpless victims of crime and violence. Although the Malimat Committee has recommended that the victim has a right to be represented by an advocate of his choice, provided that an advocate shall be provided at the cost of the state if the victim is not in position to afford a lawyer. This fails to acknowledge that the present state of implementation of the statutory provisions concerning free legal aid in the criminal justice system leaves much to be desired. The reform of the criminal justice system as whole will have to be simultaneously with the reform of the legal aid system before a victim of crime can be guaranteed an effective right of representation in a criminal trial. The limitation of resources of the state in making adequate provision in the form of a victim assistance found ought not to be countenanced any longer. The attempt at devising a statutory scheme of witness protection will have to be preceded by a wide range of consultations by the law-making body with not only victims of crime, including terrorism, but other statutory bodies like the National Human Rights Commission, which are plugged with a rising number of complaints. The approach would also have to be transdisciplinary involving inter alia, academicians, social workers and professionals from the field of law and medicine, etc. Given the endemic delays faced by litigants in the present legal system, it would be appropriate to implement legal reforms without diluting the need for providing fair and equal justice to victims of crime, including terrorism. The United Nations resolutions on human rights of victims of terrorism will serve as a useful benchmark in recording the state agencies to address the victims of terrorism. Thank you.